those names.
Okay, so if it was in a trust, we
put it into another trust
and then have it conveyed to another trust.
Right, different name, yeah.
Yes. Okay.
On the lease thing, are you talking only California, or what about judicial states?
I'm talking about everywhere.
Everywhere, it's all the same.
Yep. Yeah, if the lease is recorded, the new buyer takes it with the lease. Now imagine this, imagine the lease is recorded on the public record and got recorded before the sale, and the lease says that you only have to pay $100 rent for the next 20 years. It's a 20-year lease and your rent's only $100 a month. And not only that, but you know what? Here, I'll go ahead and give you a receipt showing that your rent's been paid for the 20 years. Wow.
Wow.
Yeah, I heard wow.
So does this need to be recorded before
Leases
a
have
notice
to
of
be
default?
before the sale.
Just before the sale? What if it's dated before the sale, but it's not recorded?
I don't know about that. I know first in line, first in time, so I don't think that would, that's why I said the tenant can still prosecute it, but they would just have to bluff their way through and not bring any mention, and hope no mention is brought to the fact that there's no file stamp on it. Just stand, well, it's a lease, it's a lease, it's a lease, you know, just stand on that, yes.
Well, what if the market value is $1,000 for that house, and can you lease it out for $100? That's not going to be an issue. I mean,
Okay.
Anything you want.
What right do you have to come and tell her that she can't rent that apartment to me for $100? By what authority are you coming and telling her and interfering in our agreement?
Just get it into the public record.
By what authority are you interfering with our agreement? Are you, did we ask you to step into our agreement? No, we did not. Have a good day. Or pay me for the trespass.
What about if there is, it's not the word delay, you had mentioned it's, but
Buying time.
Right, but if there is the sale was to take place and got delayed out a month, can you use that time to do a lease in between that?
Right, yes.
Wow.
That's what the guy over there in Phoenix is doing. They've stopped the sale for 4 months in a row, and every time it just gives him more time to get his administrative procedure done.
Thank you.
Yeah.
And if you had if this sale went by and you had those tenants in there, but you had a lease notarized, but you just never recorded it, and you are the real
That's
creditor,
between the tenant and the new owner.
but the old-
You're out of it. You're out of it.
Because you didn't record it.
You're out of it anyhow. It's not your lease anymore. It's not your home anymore as far as the
We're gonna go
record's
get it
concerned.
back though.
Right, that's a separate issue.
Okay.
That's not what we're talking about right today. Yes.
But if the lease is not recorded, can then the new owner of the property evict the tenant?
That's why I just said the tenant wants to kind of bluff their way through it and not bring mention to the fact that it's not recorded, and bypass the fact that it's not recorded, and not talk about the fact that it's not recorded, and just
saying
talk
I
about
have
the
a
fact
lease.
that I got a lease.
And when they ask for the $100, give them the $100.
That's right, give them the damn $100.
They're gonna want the
That's right.
rent roll.
Oh yeah, of course.
That's right.
They will.
Because you got to understand, eviction has two elements, and two elements only. Don't go into an eviction talking about, I own the house, the bank doesn't own the house, because it doesn't matter. It's not one of the elements of an eviction proceeding. The two elements of an eviction proceeding in California are you the responsible party, and did you pay your rent?
Well,
That's it.
except, no, there is an exception to that rule. In California, you can only fight the title. I mean, you cannot. It's a limited jurisdiction. You can fight. You can bring a quiet title action and try to clear up the title issue. So basically, you can have a stay on your unlawful detainer and do your quiet title action. And then your unlawful detainer will be dismissed because you have done your quiet title.
Well, that's all true, fine and dandy, but that's not what I said. What I said was there's only two elements to an unlawful detainer case. Don't try and go into an unlawful detainer case talking about title, because that's not where you do it. You do it in Superior Court. You're right, they have limited
It is,
jurisdiction.
but I mean, for the people who is already late, that's the only way you can get your unlawful detainer to have a stay, where you have a quiet claim file. And then you have a stay on your unlawful detainer.
Right, that's a separate action, right. But I've been getting them stopped just by doing the 99-128. The judge dismisses the case, the attorney doesn't show up, the attorney for the bank doesn't show up, the judge is...
I don't know how far they are, depending how far they are.
Eviction.
I understand. I've been there, done that. That's why I'm saying based on personal experience and the knowledge, I'm telling people what they can, maybe they cannot.
Right, right, but the elements of an eviction are still two. And that is, are you the responsible party and did you pay your rent?
Only in an issue where the title becomes, in the California law, yes, that is true, but only there is an exception. If the issue of the title arises out of a foreclosure sale, then they have to prove up the title before they can evict the
In
people.
Superior Court.
Anyway, unlawful detainer is a superior court issue, doesn't matter. And a quiet title.
Well,
you can
actually,
have
it's a commissioner that holds it.
No,
in-
it is not, depending where you are.
Right
I
here
have
in
been
San
there, done
Bernardino,
that, you know.
they have a
I'm
commissioner.
living
Get on with
proof
the
of
seminar,
that.
please.
They have a commissioner right here in San Bernardino.
But you can
just call
always
commissioner.
refuse to have a commissioner
Sure you
hear
can.
your,
Yes,
case.
you
That's
can.
your right also.
They're all administrative law judges.
Right.
But you don't have
They're-
to.
none
It's
of
an
them are
administrative
Right,
procedure,
none
it's
of them
not,
is a judge.
yeah, it's administrative procedure, it's not a court case.
Right.
Whatever.
Okay, so anyhow, for people that are already out, okay, we have a few remedies available for people that are already out. First of all, the first question that I suggest you ask yourself is, or the first thing you establish is the house empty or vacant or lived in?
Empty.
Is the house being lived in by a man and woman who have purchased the house believing that they're moving on with the American dream?
Yes.
Then you have a moral quandary that you must address and you must get past. Do you wish to teach these people that there's no such thing as Santa Claus? If that's part of what you're planning on doing, then move forward with it. If you don't plan on breaking these people's bubble and let them continue to believe there's Santa Claus, Easter Bunny, and Tooth Fairy, then leave them alone and walk away.
There's no tooth fairy?
Now you tell me.
So there's your moral quandary if there's somebody living in the house and it's a family. Okay? Now, once your moral quandary is eliminated, whether or not you choose to move forward, full speed ahead no matter what, or if the house is vacant, several different ways you can do it. First thing I suggest is you go down to the county treasurer's office and you find out whose name are the taxes in.
County.
Treasurers. And you ask them, whose name are the taxes in? Now remember, the gatekeeper is going to try to tell you that the bank owns the property. I did not ask who owns the property. I don't care who owns the property. What I want to know is whose name are the taxes in. Because what I've discovered personally is that banks are lazy, lazier than I am.
Yes.
And what they will do when they foreclose on your home is they will, they can hold that house up to 5 years? So they'll sit there and they'll hold that house, and the tax man isn't going to come around and foreclose on it. But they're going to pay the taxes anyhow, so it's not a matter of it going into default. Although it already is because it's a year behind, right? So when you find out that the taxes are still in your name because the bank didn't transfer it back out into their name, then now what you found is that there's something on the public record that says you owe something. And it's not true, correct?
Correct.
So, can anybody tell me what our immediate remedy is today? Monday morning?
A for B.
Hey.
No?
It wouldn't be a
Pay
release of
7
a
Claim
years.
of right.
Hey.
Pay the taxes.
Thank you.
What is it?
For 7
Pay the
years.
tax. Pay the tax. Pay the tax.
Pay the tax, but someone mentioned A for B and that's.
Do I want the bank giving me an A for B? No. Pay the tax. Cash.
The whole.
Pull a Federal Reserve note, a $100 Federal Reserve note out of your pocket and tell them, I don't have enough to pay all of this today, but I want to give you $100 and make payments on it every month. Is that okay?
Boom.
They'll be happy to do
And
that.
get them to fill out the agreement, sign the agreement. You look quizzical at me. Are you wondering why you're paying taxes on a house you don't owe anymore? Is that what you're-
Establish.
No, Aurora has just sent me a letter indicating that they're going to set up an escrow account and they're going to pay the taxes and that they're going to be adding it on to what I do owe.
That's so they can.
You have Aurora?
They don't really
Yes.
pay the taxes.
Have you gotten any notices from McCartney, Holtis, and Levine or Quality Loan Services?
No.
Why are you paying
So
tax?
pay the tax.
Why?
Right, you're going to pay on the tax and you're going to pay cash.
Do they have the agreement there, or?
The treasurer, hell yeah, they have an agreement to pay back taxes. To make monthly payments on taxes, yeah. They have
Okay.
Jerry, you said